When it comes to intellectual property, most businesses don't lose money because of a lawsuit. They lose money because of preventable mistakes. Using photos they don't own, waiting too long to address infringers, waiting too long to protect the underlying assets through proper registration, ignoring copycats, or perhaps giving away valuable confidential business information. And many businesses don't realize the mistakes until they're hit with huge expenses. In this video, I'm going to walk through 10 mistakes that businesses make as concerns intellectual property rights and how they can avoid them. My name is Elizabeth Seltzer, and I'm an intellectual property attorney with over 30 years of experience assisting businesses of all sizes in navigating trademark and copyright issues. On this channel, I break down complex legal issues into practical guidance that you can actually use to assist your business. This channel is for general educational and informational purposes only and does not constitute legal advice. Viewing this content does not create an attorney-client relationship, and laws vary by jurisdiction. Mistake number 1, choosing a weak or unavailable trademark. So often I see businesses brainstorm internally about picking a brand or a slogan or a particular name and logo for their business, but they don't seek external advice and assistance. And then the big mistake is they fall in love with the concept they created for their brand or their name or their slogan, their logo, and then they proceed in using it. But they fail to ask the pertinent questions at the onset. Can I use these and can I protect them? In particular, is what they plan to use, is it being used by third parties, or perhaps is it just generic or highly descriptive, or maybe does it even fail to function as a trademark? And failing to clear use of a particular mark or slogan or logo causes a lot of problems down the road. It can cause litigation costs, it can cause customer confusion, and it can cause a weakening of or a loss of trademark rights. Then the company's hit with not only the cost of the litigation, but then they must launch into an entire new rebranding campaign, which adds another layer of expense. Just general advice: do clearance searches before use, competent clearance searches. That's including not only looking at what is at the USPTO, but what's out in the marketplace, because trademark rights are acquired through what's called use in commerce. And when you're picking your mark or your brand, it should be distinctive. Mistake number 2, thinking that registration creates trademark rights. So let's move on to the issue of businesses think often that trademark rights are just simply acquired by filing a trademark application and then getting a registration. As I just mentioned, trademark rights are not acquired that way, although registration does give a significant amount of benefits to those who seek and obtain registration, but trademark rights are actually acquired through what's called use in commerce. As I mentioned, registration gives a host of benefits to the applicant who eventually obtains a trademark registration. But timing here is also important, because waiting too long can cause a host of issues with potential other users who may have been out in the marketplace and using a similar mark prior to the timing of the filing for a trademark application. Waiting too long and then relying on the fact that you have a registration only and didn't look at the issue of use in commerce also can harm the business's potential to expand into other regions. And also it may be a situation where the other users are coming into that business's region and then causing another layer of complexity. So tip is, use your mark properly and explore registration prior to launching into a full-scale marketing campaign surrounding this particular chosen brand or logo or slogan. Mistake number 3, waiting too long to register copyrights. When it comes to copyrights, Timing is also essential as to the issue of when you seek registration. So often it's the case where the business or the particular individual thinks, well, I created it, therefore I'm protected. So often is the case where failing to file a timely copyright registration may hinder that business or individual's ability to leverage certain damages in the case of enforcing against a third-party infringer. So if your business depends upon creative works such as writings or drawings or paintings or visual works, you should incorporate a copyright registration strategy into your practices.
Mistake number 4, using photos found on the internet to put into marketing materials such as a website.
A particular problem for many businesses and individuals in the field of copyrights is that they often, if they're creating a website, let's say, they often assume that they can just grab photos off the internet and place it onto their website. That is inviting a host of issues. Such images found online, although viewable and may be used even by third parties, are not necessarily free to use for all to just take and put it on their website or into marketing materials. You certainly don't want to invite litigation into your business practice. So you should obtain licenses for any content that you find online and use. There are companies out there who license images for use on websites, and you particularly are looking for commercial licenses.
Mistake number 5, failing to own the rights to content that third parties create.
Another issue that often plagues businesses and in the field of copyrights is that they hire a third party, let's call them a contractor, to create a work for them. Let's say, for example, a logo or a website. And they assume, because they paid that third party, that they actually own the underlying copyrighted material. What's really important here is the contractual relationship you have with that third party. In particular, if you're a business or an individual who is using materials created by a third party, if it's the case that you want to own it for use, then you need to make sure that your contractual agreements have certain provisions that assign rights to you to own that particular work. But it may be the case that you don't want to own it, but you license it. But again, the key here is to be aware of the fact that just simply paying someone to create something for you doesn't necessarily mean that you own it. So the tip here is to make sure that you have contractual agreements in place that address ownership of the created work, or if it's not ownership, licensing terms.
Mistake number 6, failing to protect confidential business information.
Often businesses have certain information that is valuable to the profit of their business and the functioning of their business. In fact, some have something that's so unique that it's their key to success in the marketplace. And this information can be deemed confidential business information, or also known as a trade secret. So maintaining the confidentiality of that particular information is very vital to your business. And so certain measures need to be in place to retain that secrecy or confidentiality.
Mistake number 7, disclosing confidential business information without NDAs in place.
One way that such information can be protected is when dealing with a third party, let's say a vendor or some type of third party contractor, developers, investors, for example. You need to have in place proper non-disclosure agreements. But here's the thing, sometimes as businesses grow, this confidential business information, although known internally to all the employees of a company, those employees themselves may inadvertently disclose information to third parties in doing business arrangements. So if you're a business who really benefits and utilizes some type of confidential business information, you want to have protocols in place to make sure that your one of your major assets there, that trade secret, is maintained as confidential.
Mistake number 8, ignoring third-party infringers of your trademark.
Going back to the issue of trademarks, one of the mistakes that businesses make is just simply ignoring third parties who are infringing upon their particular trademark. When you obtain a trademark registration, to maintain your trademark rights, not just the registration, but just your rights in general, you are expected to maintain and enforce your rights. Ignoring these third-party infringers and not enforcing against them can not only cause a weakening of your trademark rights, it could cause a complete loss of your trademark rights. So businesses should be monitoring third-party use of their particular trademarks, and when the use seems to be an infringing use, then it is necessary to maintain the strength and the complete rights of that particular mark. Action should be taken against that third party, and that action can vary, but it still should be an effort to enforce and maintain their trademark. So not every use by a third party requires litigation, but there are certain measures you can take to ensure that you are enforcing your trademark rights.
Mistake number 9, failing to do quality control when licensing trademarks.
Another issue with trademarks and businesses is that as businesses grow, let's think in the scenario of franchising, for example. That business may want third parties to legally use their mark, and they give them a license to use that mark. But when granting licensing rights to third parties, certain obligations fall on you as the licensor to make sure that licensing terms are being complied with, and then secondly, that you are exercising what's called quality control. So an issue for consideration here is that when you're licensing to third parties, make sure not only that the underlying licensing terms are favorable to you, but that you are in touch with and continuing to monitor and do quality control on the use of your mark in compliance with the terms of your licensing. So a key takeaway here is to have adequate licenses in place, and then secondly, to make sure you have some type of meaningful oversight of those third parties under such licensing scheme.
Mistake number 10, assuming IP protection is set it and forget it.
So overall, regardless of the IP right, trademarks, copyrights, trade secrets, even patents, proper monitoring and maintenance of all of those are very relevant. Businesses should have systems in place to monitor any type of renewal concerning a trademark, keeping tabs on infringers out in the marketplace, have internal procedures in place to protect confidential business information, review and update any agreements used with employees internally and those parties externally as concerns the protection of your intellectual property rights. I mean, ideally, create some type of internal IP checklist and follow it and monitor it and update it as needed. If there's one thing I want to highlight in this video, it's to make businesses be aware of the fact that all of these issues can be addressed at the beginning before launching into use and exposure of any of your intellectual property rights. If I've touched upon any particular topic here that you would like to see developed into a separate video, let me know in the comments. I'm happy to create such a video. Thanks so much for watching, and check out these next videos that relate to intellectual property for your business.